Did you always or ever think someday I'd love to be on the Supreme Court? Or was this one of those, I know that you were nominated once and then you got, I mean, I understand your nomination, but did you ever think someday I'm going to be a Supreme Court justice?
No, those are two different things. Most lawyers think it would be very nice to be on the Supreme Court, but most, being pretty realist, understand there's a lot of luck involved in any kind of appointment. So they don't expect to be on the Supreme Court, and certainly I didn't. When you are a judge, particularly on the Supreme Court, it could be the most technical case in the world. You better learn it. You better figure it out. You better take the time. And the fact that it calls from you what you have to give is perhaps its greatest virtue.
That's what you miss about the court, you were telling me, though, that ability to kind of think toward the future.
Yes.
And figure out these problems.
Yes.
What else do you miss?
Well, I like the people. I mean, I did actually. It wasn't phony.
All of them.
Yeah, the political people want to say, they desperately want to say that the judges are deciding on political bases. I don't think that's true. I think
people do say that now.
I know that.
I mean, that is a narrative about this Supreme Court led by conservatives. You don't believe it?
No. I think what happens, it's more complicated. It's more subtle than that. What happens is people who are very interested in politics try to convince the appointing authorities to appoint a judge, and they've looked at his work and so forth, appoint a judge or someone else who honestly believes that this way, X way, textualist way, originalist way, for example, is the right way to decide a legal case. And then we'll get a lot of what we want. But the people who are thinking politically are the people who are urging the appointment. When the judge decides the case, he thinks he's acting like a judge. Now, that makes a difference.
I think a lot of people will be surprised to hear a liberal Supreme Court justice say, oh, no, they actually have good intentions, I just disagree with them. It seems like a lot of people believe that they're coming at this from a place of bad intentions, that they're corrupt, that the court has gone off the rails, that they're political. No, How dangerous is that? Or what is your take on that?
I think that's unfortunate that they think that, because I think that's inaccurate, really. And when I talk to the high school students, I like talking to high school students, and I'll take out my copy of the Constitution.
Which you always carry with you?
Well, it's in most of my suit pockets. You never know when somebody asks you a question.
Do you have a Constitution in every suit coat?
I don't know if I have a Constitution.
But you don't just have one that you take around?
Oh, no. They're not very expensive.
Because you do say in the book that this way of looking at the Constitution with originalism is actually, that way of looking at the Constitution is harmful to that document. So. You use the word harmful.
Yeah.
And that it can potentially mean that the Constitution, if we keep looking at the law the way the conservatives on the court do, that document may not pass the test of time. Those are pretty...
There are risks.
Risks.
There are risks, and believing that someone who basically disagrees with you about how, say, to interpret this document, or about other similar things, believing that they're not necessarily bad people doesn't mean you have to agree with them. It doesn't mean that you have to go along with the way they want to do it. And I think what's happened here, and that's what I've written about, is it's very tempting to think all you have to do is read the words. That's textualism.
Yeah.
Read the words. Okay, I'll read the words. All judges read the words in the statute.
But that's not enough.
No. I'd say there are other things. You want to find out somebody wrote those words in a statute.
The purpose. Why? The purpose.
Yes. Why?
The values.
Why? Yes. Values.
The consequences.
Yes. And you look at, that's what Marshall says, John Marshall, the great Chief Justice. He says, in a complicated case, you use the weapons that will help you, the tools that will help you. Don't limit them. Don't limit them. See what is helpful in trying to interpret this Constitution so that it fits within what the people wanted, the values that it contains, the statutes serve a certain purpose, what? And that will probably help produce an interpretation of law that will in fact help people live together peacefully, live together more productively. And we've got to do that now, not with 4 million people, but with 320 million. And so far, we've done it. Well, we've had a few errors, slavery, Civil War, so forth, Jim Crow. But by and large, it's still there. And that helps keep us together.
What is your method of interpreting the Constitution, focusing on the purposes, the values, the consequences? You call it, your approach is the more traditional approach. And you write in the book that law must function so people can live productively and freely. That's an important part of the law. But in some of the cases that we've had and that you write about and that you say, I mean, the alternative approach that seems to have a majority on the Supreme Court right now, do you think that's having harmful effects on the development of the law?
No, yes.
Yes.
Yes, I do think that. It sounds good. You see, it sounds good. It sounds, one, I promise you as a textualist, my way of interpreting the Constitution and the statutes. It's simple. You just read it. And moreover, it will stop the judge who wants to substitute what he thinks is good for what the law says. He won't be able to do that very easily. I'll stop him in his tracks. So we'll get the laws passed by Congress. We will not get just what the judge thinks is good.
Not the judge's policy preferences.
Correct. And it will be helpful to Congress because they'll know what to write to get their way. The text.
Clear rules.
Clear rules. And it will make it fairer because across the large number of laws that are being interpreted, they'll come out roughly the same way with the same words. What a promise. 4 wonderful promises. And I think that accounts in large part for this method of going about interpreting statutes, interpreting the Constitution. Look back and see, what did these words mean when they were written to the average person? Popular. Popular because it sounds simple. And what I want to say is, no, it isn't. No, it isn't simple at all. Most of the words in the statutes that we have in a constitutional case or in a statutory case in the Supreme Court, they're not so simple, or why are they in the court? I mean, you read the word cost. It's in a statute. Cost. I know what it means. I always read the statute first, of course. If it says fish, that doesn't mean a flower. Got it. But it isn't that simple. Cost? There's a statute which says if you have a handicapped child, you can ask the school board to have a special education, and if you think what they're giving that child is not good enough, you can go to court and you can win. And you know what happens if you win, among other things? You get a better education for your child, but it's expensive. You have to pay for experts. Well, if you win, can you get the cost of paying for the expert? Is the cost of the expert a cost? Yeah, of course. So do you obviously get it? Well, maybe not. Maybe they just mean the cost of the lawyers. Oh, what is it?
But look at the law.
Yeah, look at the law. There it is. It says the word cost.
Right.
Oh, well, thank you very much for all that help. You see, so you look back and see, what did they say in Congress? And what you'll discover is every member of Congress voted for a report that said that word cost includes the fee of the expert. But our court said it didn't.
You talk about several deficiencies in the method of originalism, and I want to use Dobbs to talk about several of those. Number one, it's deeply regressive. You write that this method is deeply regressive because, when the Constitution was passed, when the 14th Amendment was ratified, who were the lawmakers then?
Oh, exactly. And as you are aware, they didn't include the women. They
People
didn't
of
include
color.
the slaves. And so go back
White,
and say that's one problem. I'll give you another problem. Dobbs overruled cases that had been on the books for 50 years or more. Well, really? Now we're going to go overrule cases? We can do it sometimes, but you better be careful. You overrule too many cases and law will turn into chaos. Every client will say, lawyer, my lawyer, go overrule 5 cases, get them to overrule it. And before you know it, you won't know what the law is. So that can't be it. Well, what cases are they going to overrule? Those that were not done by an originalist or a textualist method? That's all of them, or nearly all. Let me not exaggerate.
You say it's unprincipled.
Yeah.
There are no principles.
But what is the principle? Is the principle that you think those cases decided then were really wrong, egregiously wrong, totally wrong? Oh, I see. You have to look to see whether you think they were really wrong. And how are you going to decide that? Well, I don't know. It's beginning to sound familiar. Now it's beginning to sound that you are going to take the cases that you think were really wrong. That sounds an awful lot like the judge substituting what he thinks is good for the law. The very thing, the very characteristic that the textualists said they wanted textualism to prevent. So how did it prevent it?
I mean, you've written this book because you still have hope. It's not all the way there yet. Like,
Correct.
we are in the middle of a paradigm shift, as you put it, but we haven't, you say, but
yes.
maybe we haven't gone all the way there. And so
Yeah.
there's optimism, right?
Yes.
And you say that some of these justices that decided Dobbs had only been on the court for a couple years. They're
correct.
new. And you write the way you write that they will see.
Yes.
Do you think these justices, being so new, made an error in Dobbs, but they're still potentially will see
Yes.
that error? You have hope.
I don't know if they better go back and overrule Dobbs or not, but an approach.
Would you have joined the Chief Justice's opinion in Dobbs if it had come down to that?
As a majority or as a preventing of the overruling, I would have had to decide that at the time.
I wondered, would you? Would you have considered
Well,
it?
I haven't. Hypotheticals are
To prevent the overruling of Roe.
Oh, maybe, and maybe not. I mean, but maybe.
But it was moot with the addition of Justice Barrett.
That's right. Maybe I would have, and then we wouldn't have overruled Roe, and we wouldn't have overruled Casey, and we would have been a 15 months instead
15
of
weeks.
15 weeks instead of whatever, and a lot of European countries have that. There was a lot to be said.
You
for
might
each
have
of it.
considered that.
I certainly would have considered it. I might have joined it. I didn't have to decide it, I'm sorry I didn't have to decide it, because it meant that Roe and Casey were overruled.
But that shows to your point about listening and trying to find
compromise, take 30% rather than no percent. Not always true, but generally.
You've written this book for an engaged audience and it's an important book. I think you've written this book also for 3 of the new conservative justices.
That's up to them. I might like it if they read it, yes.
But you say in the book, they're new.
Yeah.
You believe, we'll see.
Yes. That's what I think.
You think what?
I think that we'll see. They'll be there a long time. We'll get 9. We got 9. We used to get 9 about 40% of the time. And 5-4 was about 15%, 20%. And in that conference room, in 28 years, I have never heard a voice raised in anger. I don't think ever. It's polite.
Ever.
I can't think of ever.
Not even Bush versus Gore.
No. I think they were wrong. So I can say that. I said, this is not a good idea.
But you didn't shout it.
No, absolutely not. People respect each other. They respect each other's points of view. They don't necessarily agree with those points of view, but then say why. And what I end up usually telling the high school kids or the law school kids, and they say, well, what should we do? I say, what should we do? Get out and participate, but you want me to be detailed? I'll tell you something. I'll tell you a secret. It's not my world anymore. It's yours. And you're the ones who will decide how to keep it together. So go out there and do it.
You have a quote early in the book, and I want to ask you if you believe what the quote says. Do you really believe in hell there will only be law and nothing but law?
Well, I'm not sure I would go quite that far, but many people have.
Justice Neil Gorsuch in Overruled throws the book at the law.
You write that law in America has swallowed up ordinary people, intentionally or unintentionally.
Oh, I think all with the best of intentions. I've been a judge now for about 18 years, and I just saw so many cases where ordinary Americans, decent, hardworking Americans, were just trying to make their way in life. They weren't trying to hurt anybody, and yet they were caught up in the legal system in ways they couldn't hardly expect. It's a book of stories about the cases I've seen, that other judges like me have seen, cases about fishermen in Florida, monks in Louisiana, a magician in Missouri, and their experiences in a world where law has really exploded just in our lifetimes.
Are they victims?
Well, I don't know whether you consider them victims or whether you consider them emblematic of a world in which we just have so much law. Federal crimes have maybe doubled in our lifetime. Nobody knows how many federal crimes there are because it would take years just to read them. We have more people serving life sentences today than we had serving any sentence in 1970 or thereabouts. So that's the world we live in, Major. Why? You know, I'm not a psychologist or a social scientist, but I think some of it has to do with trust. I worry when more and more Americans think that people in the other political party are not just wrong, fine, but are evil. I worry when we are unable to speak to one another and listen to one another. Let me give you another example, if I might. Is that all right?
Sure.
Marty Hain from Missouri. He's a backyard magician. He does children's shows. One day, he's doing his show, and he pulls a rabbit out of the hat. Got to do that, right? And somebody comes up to him and says, "Do you have a license for your rabbit?" And it shows a badge, U.S. Department of Agriculture. And he says, "Why, no, I don't have a license for my rabbit. Do I need one?" And they engage in a conversation. It turns out if it had been an iguana, no license required. If he had intended to use his rabbit for stew that evening, no license required. But because he pulled it out of a hat at a children's show, he needed to have a federal license for his rabbit. Well, Marty, I don't doubt the agent had every good intention in the world. But I also don't doubt that Marty had every good intention in the world. And, of course, he dutifully applied for his license, and he got his license. Sometime later, he got a notice, though, that after Hurricane Katrina, he had to have an emergency preparedness plan for his rabbit. And it had to cover everything from hurricanes to chemical spills. Well, Marty explained to an agent that he lives in Missouri, and there are no hurricanes, and he keeps the rabbit in his house. But he does have some worry about tornadoes, and his emergency preparedness plan is to make sure the family's in the basement, then the family dog and the cat, and then, if there's time, the rabbit. Well, that didn't go over well either, as you can imagine. The agent said, "Well, I only care about the rabbit, the cat and the dog, I don't care about this. So the rabbit has to come first, fine." He wrote a 28-page emergency preparedness plan, had to hire a lawyer to do it. And the lawyer was a little concerned that it wasn't detailed enough to satisfy the federal regulators, but he got away with it. Later, he had, of course, a home inspection visit for his rabbit, and they wanted to see the cage. He kept Casey the rabbit in, and he showed him the cage. And the agent said, "Well, it doesn't have a sticker pointing this way up, so how do you know how to carry the rabbit safely?" And Marty said, "Well, there's a handle on the top." That didn't go over well either. So he said, "Well, where do I get these stickers?" And the agent said, "I'll send you some." 2 weeks later, he got 200 stickers in the mail. Your tax dollars at work.
And that's unintentional but harmful.
Well, it's costly for everybody involved, isn't it? And one has to ask, where are we in this? Again, too little law, danger. Too much law, we have to worry about that too. And what's happened in our lifetimes?
Having read the book, would I be wrong to wonder if your observations about COVID influenced the arc of the book or reinforced some of the concerns you're raising?
Yeah. Well, I think COVID is an interesting case study of what happens when lawmaking moves from the legislature, during that period of time, legislatures largely fell silent. So did courts. And we lived in a period with intense regulation from executive sources, edicts, decrees.
Governors, mayors, county commissions, etc.
Changed week by week, jurisdiction by jurisdiction. Now, that was very important, obviously. I mean, it was a very dangerous time in this country, and we needed some emergency rulemaking, obviously. Everybody knows that. And there's nothing new. James Madison would have said the same thing, that in times of emergency, the executive has to act strongly. John Locke would have said the same thing. But it is worth asking what happens when rulemaking goes out of the legislative branch and into the executive branch. And in that, COVID had some instructive things in it, I think. First of all, what happens to equality? Who's best able to deal with shifting regulations that change from week to week, from place to place? Maybe the bigger companies? Maybe the small mom and pops have a harder time with it? Well, you saw during COVID that billionaires saw their net worths increase by 70%, while mom and pop businesses lost out. We saw regulations, it was unlawful to congregate on street corners, but who were those rules enforced against? There's a fair amount of evidence that suggests they were disproportionately enforced against African American citizens. So I think there are some questions that are worth asking.
Were religious liberties infringed upon at that time?
Well, those cases obviously came to the court, and a classic example out of Nevada. Who do you think benefits when decrees are made without the involvement of the legislative branch? Maybe favored industries. Casinos were allowed to remain open. Churches were closed. So I think that's the answer to your question.
You are known on this court and throughout your legal career as having a keen eye for the legal interests of Native peoples, Indigenous people. What is their story in the relationship to the things you're writing about in this book, and why is that an area of law in which you have distinguished yourself, even from colleagues who are regarded as like-minded textualists or originalists?
I think the starting place has to be with the fact that this country made a lot of promises to Native Americans. Treaties, often negotiated under duress, but treaties nonetheless. Promises made. Mm-hmm. And I think the question is, for every judge, do you honor those promises in the cases that come before you? And I think a textualist, an originalist, as you talk about, can look at the words on the page and say, that's what was promised then, that's what they're entitled to today. There's a saying that men must turn square corners with the government. Shouldn't the government also turn square corners with the people?
Mm-hmm. And that's been your intent in cases brought before you?
All cases.
All cases.
But in a recent poll, 70% say Gorsuch and the other current justices decide cases on ideology rather than being fair and impartial. On that, Gorsuch respectfully dissents.
I read the other day that in ideologically divided cases, now I don't know what that means, this last term, that I agreed with Justice Sotomayor, Justice Kagan, and Justice Jackson something like 45% of the time. That's the court I know.
But there are people who watch this right now and say, I thought I understood what Roe versus Wade meant in our country. I thought I understood what affirmative action in college admissions meant. And this court has told me I didn't understand what those things meant, and I wrongly relied on things that I thought were settled. What would you say to those?
I'd say those are deeply complex legal questions on which reasonable minds can, of course, and do disagree. I'd also say to you that shouldn't we start from a presumption that those with whom we disagree love this country as much as we do? And that there may be good faith legal disputes on these questions? And then when it comes to Roe versus Wade, for example, what did the court decide? Decided that we, the people, should answer that question, not 9 people sitting in Washington, D.C.
How about affirmative action?
Much the same thing. What did we decide? We decided that all people are created equal, that it's not acceptable in this country to discriminate on the basis of race.
And for those who would say, but I feel something's been ripped away from me, you would say?
I would say that we're taking it back to you. In a democracy, you're in the driver's seat. You're the sovereign. Those famous three first words of the Constitution empower you. Do you really want me deciding everything for you?
And for a woman in a state where she no longer has the rights she once relied on, is that cold comfort?
Major, all I can say is I don't know better than you do on these questions. There's no legal training or expertise that gives me any special insight into these questions, and that most major Western democracies have decided these questions through the ballot box, and they've managed to reach a consensus on these questions, and I have great faith in the American people to do the same.
As an election approaches here,
we need a mandatory code of ethics for the Supreme Court, and we need it now.
President Biden is pushing for stricter ethics rules and 18-year term limits for justices, in response in part to pricey travel paid for by Republican donors.
Major, as you know, we adopted an ethics code just this term, and I think that was a significant step.
Do you believe that is sufficient?
I think it's remarkable that we were able to agree unanimously.
Does this court, today or in the future, have to understand and care about its public perception?
You raise a really interesting question about the place that unelected judges have in a democracy. An independent judiciary, our founders fought a revolution for it because they knew what it was like to have a judiciary that was responsive to the crown, to a whimsical king. And they didn't want that for this country. And the truth is, when you're the man in the dock, you don't want it either.
You just referenced the king. How does that orientation, historical and otherwise, flow through this term's decision on presidential immunity?
Well,
some Americans fear it comes close to creating a kingly-like protection for the presidency.
Well, we can talk about that, but let's start with where we agree. I think everyone agrees that a president in his private capacity, non-official acts, when he's a citizen, acting like a citizen, even when he's in office, is subject to the criminal law just like you and me. No man is above the law. We also agree that when a president's in office, he can be impeached for his misconduct and removed from office.
A political construct, not an entirely legal one.
A little bit of both. The Chief Justice presides. There's a trial. It's not done by us, but there's a trial. But he can be removed from office. We also agree his illegal actions can be enjoined. You can go to court. You asked about the emergency docket. You can go to a court and seek an injunction to stop illegal behavior by his subordinates. We all agree on that. Longstanding precedent of this court, Nixon versus Fitzgerald, deals with what happens to a president after he leaves office and is sued privately after he leaves office. And the court held that you can't have a president fearful of civil lawsuits that might chill his behavior while he's in office too much, so that he's presumptively immune from civil lawsuits after he leaves office. There are exceptions. That can be overcome. Everybody knows that. That's been the precedent of this court. The question before us this last term was what happens, and this is the first time it's happened in our history, what happens when one presidential administration brings criminal charges against a former president? And the court basically held that the Nixon versus Fitzgerald framework is the right way to think about that for his official acts. That there's a presumptive immunity, but that presumption can be overcome. If he's bribed, he can be pursued, even though that was an official act. That was an example we gave. And of course, there was an indictment before us with specific charges, some official, some unofficial, and we remanded it to the lower court to sort that out. So that would be my answer to your question.
There's a long arc of cases that led to the overturning of Chevron. Wasn't the only case. There were cases before that. To those Americans who fear that that now leaves a space for large, moneyed corporate interests to get their way and browbeat the administrative state and avoid the kind of regulations that Congress either asked for or by implication asked for, and are fearful about that.
I'd say just the opposite, Major. How I came to my views on Chevron was as a judge, seeing how it played out in ordinary people's lives. And I'll give you an example. Mr. Denise Robles was an immigrant to this country, married to an American wife with 4 American children. He faced 2 laws, one of which said he could apply immediately for admission to the Attorney General, and another law that said he'd have to leave the country for 10 years and then could apply. My old courts faced that question of which statute controlled, looked at it dispassionately without favor or fear to either side, and said the first one controlled. He relied on that. So he applied for admission directly and immediately to the country, as any normal person would do. An administrative agency, 8 years later, after receiving his application, said no, said the second statute controlled, said that we had to overturn the judicial precedent because of Chevron and send Mr. Denise Robles out of the country so he'd have to start all over again. 18-year waiting period. Okay? That's how Chevron impacts people. Because what it says is, when there's a doubt about how the statute should be applied, the agency always wins. And last time I checked, Lady Justice out front is wearing a blindfold. And the scales of justice are even. And that every person who comes to court is entitled to have a judge fairly and neutrally try to apply the law to his or her case. And no party is entitled to have Lady Justice peak and favor one side or tilt the scales of justice systematically in favor of any party. Getting rid of Chevron is simply a way of saying everybody gets to make their arguments on equal footing.
On the walls of his chambers and in his new book, Gorsuch holds up one founder in particular.
Who is the book for?
The book is really for the American people. James Madison, when he sat down to write the Constitution, knew a couple of things. First, we need law in our lives. And as a lawyer and a judge, I surely know that. Law helps us achieve what George Washington called ordered liberty. At the same time, James Madison knew that too much law in our lives can destroy those same things. Law contains this irony. Too little is dangerous, too much is dangerous. And so the book really raises the question, where do we stand between those two means?
What would James Madison say if he were alive today to look at the legal landscape of our country?
Well, the first thing I think he'd say is he got pretty short shrift in Hamilton. Now, I love Hamilton, okay? It is a wonderful way to teach and learn about our Constitution and its history. But poor James Madison, I mean, it grieves me, all right? He was an incredible founding father.
Help me God.
So help me God.
All of the members of the court, I am pleased to welcome Justice Jackson to the court and to our common calling.
Applause, applause. Welcome back to CBS Mornings. That is Supreme Court Justice Ketanji Brown Jackson, as she was sworn in 2022. We all know this. She is the only black woman ever to serve on our nation's highest court. And now the justice is out with a memoir. I love this title, Lovely One. It's the meaning of her first and middle names, Ketanji Onika. She joins us for her first live broadcast interview about this book, and we are very honored, Your Honor, to have you in the building today.
Thank you for having me.
You should have seen all the people, everybody dressed up a little. We're all sitting up a little straighter in our chairs to have you in our presence. But I want to go back to that video for a second, because it's almost like dreams come true. On your Harvard application, you said one of the reasons you want to go was to hopefully fulfill your fantasy of being the first black female Supreme Court justice.
Yes.
So take us to that moment right there.
Well, you know, I had always known about the court.
Yes.
When I was young, and I talk about this in the book, I learned about Constance Baker Motley.
Yes.
Who was the first black female judge, and I just thought being a judge would be amazing, especially because my father was a lawyer.
And he would cite cases at you at 4.
He would
ask you for your opinion.
We would sit at the dining room table at 4 years old when I was 4.
But not politics? You always wanted to be in the law?
I always wanted
Because your
to be.
background also seems suited for politics.
Oh, no.
But you chose the law.
I did. I followed in my father's footsteps, for sure.
I'm curious about your hearings, your confirmation hearings, because they seem grueling to me. They seem brutal to me.
Yes.
What did it feel like? Did it feel like that to you as you were sitting in the chair? Because I was very struck by Cory Booker's words, but tell me what it was like for you sitting in that chair with a lot of incoming.
Well, it was definitely a test of stamina. It was a long time, a lot of questions, but you know, I was thinking throughout the whole time of what a White House staffer had said to me.
What did they say?
When we were preparing. She said, well, you know, you can get upset, or you can be a Supreme Court justice. And so I thought, oh, okay, this means I really have to keep my composure.
And you did that.
And I did.
I want to get to some news of day for just a second, then we'll get into your backstory, because your backstory is amazing. I told you, I'm already envisioning the movie. Who's going to play you and who's going to play Patrick? I'm very smitten with your love story. We'll get to that in a second.
Thank you.
So this summer, President Biden proposed setting term limits for Supreme Court justices and other reforms for the court. When you heard that, is it something that you're on board with? You like the idea of that?
Well, you know, what I think about when I think about proposals like that is the fact that we live in a democracy and that people are engaged and they're thinking about the court, what the form and structure and role of the court is, and that's part of our democratic process. And, you know, term limits have been debated for the longest time. In the book, I talk about Alexander Hamilton and thinking about how long Supreme Court justices should serve. So
where do you stand on it, on term limits?
Well, you know, I am...
So you're a young woman.
I am a young woman. You know, I'm not participating in the actual political debate. This is going through the process now, but I'm very interested in the fact that people are really engaged in the democratic process and thinking about the court.
You don't have an opinion one way or the other, Justice Jackson?
No, I am interested in what people are saying about it.
I hear you. Here at CBS, we recently aired an interview with your colleague, that would be Justice Neil Gorsuch, and he said in his book, he warns about the overreach of federal law and the overcomplication of our legal system. Do you think he has a point?
Well, I have not had the pleasure yet of reading his book. I know he has a book out about this issue. I think these are issues that are being debated. Whether or not there are too many laws or too few laws is also a part of the democratic process. I guess my big concern, if you want to talk about what the justices are thinking about, is a concern about the role of the court and staying in my lane as a justice and making sure that all of the branches of government are observing their own respective roles.
You had what some would call a drop the microphone moment, if you will. What you wrote, and it's been described as fiery and searing, two very strong words, the dissent in the Idaho versus abortion case. And I want to read this verbatim. While this court dawdles and the country waits, While this court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position as their doctors are kept in the dark about what the law requires. The court had a chance to bring clarity and certainty to this tragic situation, and you said we have squandered it. You certainly didn't mince words there. Why did you want to make that point so strongly?
Well, you know, a dissent is the opportunity for, you know, the justices to express their differing views with respect to what the majority has done. And I had a difference of opinion, and I wanted to make clear why I thought what I did in that situation.
Were you worried that people would think that that was too strong, or was that not something you thought about as you were writing? Because people were calling it a masterful opinion.
Oh, well, I'll let other people comment as to what they think of it. I mean, I wanted to express as clearly as possible my views on this issue, and the court has a tradition of that lots of justices use terms and phrases that they want to use in order to make a significant point.
Well, Justice Jackson, we're going to do something we rarely do. We're going to ask you to stick around because there's so much we want to really get to the heart of the book. And I have a picture that is very searing for me in a positive way. I wonder if you and I feel the same about this. I want to talk about that picture in particular. And I want to find out what it takes to prepare. You said 19 hours to prepare for your confirmation hearings. What exactly did you do, and how did you do that?
Well,
hold that thought. Oh, it starts with well. Stay with us. You're watching CBS Mornings. Justice Jackson is sticking around. We'll be right back. We are very happy to say that Supreme Court Justice Ketanji Brown Jackson is still with us. Her new memoir, I Can't Get Over This Title, is Lovely One. I love it so much. I love the cover, too. You're wearing my favorite color, yellow. The title comes from the meaning of her given names. We're so glad that you are still here. Truthfully, we wouldn't let you out the door. But I want to go back to right before the break where we were talking about how do you prepare for 19-hour days. Because at one point in the book, you write that you were clerking for Stephen Breyer, a Supreme Court justice. You said you had to bring your A game every single day.
That's right.
That it was high pressure.
That's
The
right.
stakes were high. I wonder if you felt like that as you were preparing for this,
Oh,
19-hour days.
Absolutely. I mean, it's the kind of thing where you want to do a really good job and you are getting information from all sorts of people
Yes.
about how to perform under these circumstances, and you're talking to senators when you're going to a confirmation hearing, and you're doing all sorts of things.
Did you feel you had no room for error, Justice?
Oh, absolutely.
Jackson? Did you?
Absolutely.
Yeah.
The eyes of the nation are on you as you're going through this process, and you want to do a good job.
One of the things is, as I watched you sitting so poised with taking the incoming, I was very touched by Cory Booker's time with you, because he said, I don't want to ask questions, I just want to talk about you.
Yes.
And your journey and the grit and the grace and what it took for you to get here. What did that mean to you? I got welled up at home watching it. I was very touched by that
Well, I was
moment.
so grateful for the moment of not having to answer any questions. And of course, all the wonderful sentiments that he laid out during his time. I started to cry, which I shouldn't have done, but it was so moving.
Yeah.
Yeah.
Now, sometimes tears are very appropriate, as you know. You know what got me teared up was a shot of your daughter, Layla.
Yes.
She's sitting there, the look on her face and on your husband Patrick's face, the way the family was looking at you. Look at Layla. She's just sort of turned to the side. It was such a moment of pride. When you didn't see the picture in that moment, but when you saw that picture,
yes.
What did you think? It seemed to say so many things to me.
Well, it did, and so many people came up to me and talked about how that picture had moved them. I put that picture in the book.
Yeah, I saw it.
Talk a little bit about my relationship with both of my daughters, including Layla, and how I realized how proud she was of me, which was a wonderful feeling.
But I have to say my favorite section would be all things Patrick. Patrick, we should say, is in the studio today. Because Patrick believed and Patrick knew that this was going to happen for you. Talk about somebody who believed in you in the very beginning.
He did.
But I love the backstory of your meeting, because I tell you, I already see the movie. But you met him because he was a white student who was participating in taking down the Confederate flags.
And we were in a class together called The Changing Concept of Race in America.
Yes.
And we met each other, we were friends, we were friendly, we weren't dating or anything, but over time we really started to develop a friendship, and I started to like him, but I didn't tell anybody.
Well, it was always sort of, he's my friend, he's my friend. And even your friends were like, what's going on with this dude?
Yes.
But then it gets very serious, and comes a moment to take you home.
Yes.
Now, he comes from a very privileged background, it seems in the book.
Yes.
And you were worried about meeting his family for the first time.
Yes. I mean, I was just nervous about the whole scenario. My parents had grown up in the South in segregation, and, you know, this was an interracial relationship, which was unusual.
Was
much
that
more
scary
so
to you, an interracial relationship?
It was,
Yeah.
and certainly one with someone who had such a different background than
Yeah.
I did. It was sort of like hard to think about how this was going to happen. But I wanted my parents to trust me, and
I know, but your parents said, we trust you, we trust Patrick, but this is America.
that they did say that.
Your dad said that.
My dad did say that, and eventually, you know, they realized that we were right for each other, that we shared a lot of the same values.
But this was the thing that got me with Patrick. You're getting ready to meet the family. You're not sure how it's going to go. And what did he say to you?
He said, he said a couple things, but at one point he said, I choose you, because I was worried that, you know, his grandmother had promised to pay for his medical school. And I was worried that it might mean that when she found out about me, she wouldn't do it. And he said, even if I have to take a job or do something else, I choose you.
I choose you. What did that mean to you?
Oh, it was it was pretty extraordinary.
Oh, I know. I melted. And the other thing that I really love, you're walking across Harvard campus.
Yes.
A black woman is approaching you.
Yes.
You don't know her.
No.
And she says just one word that I thought was life-changing.
Well, I was feeling really depressed at the time. You know, so many freshmen go through the, you know, imposter syndrome.
Yeah, you weren't sure you belonged at Harvard.
I was not sure. You know, I'd come from a big public high school, and here I was in this place. And this woman passed me on the path, and she leaned over and she said, persevere. And then she kept going. And I was like, wow, you know, and it just really stuck with me and started to change my view of what I was doing there.
And now that you are an official Supreme Court Justice of the United States, is it everything you hoped or thought it would be? Do you still like the job, Justice Jackson?
It is such an honor to do this work. I'm so privileged to have the opportunity to serve in this way and very grateful.
Well, you should know so many people are cheering you on. We don't normally have, Secret Service agents in the studio. People who normally aren't even at work at this time are here because we all wanted to see you and pay our respects. And I'll see you tonight at the Apollo.
Yes,
We're doing
ma'am.
a Q&A. And you're doing Stephen Colbert.
I am.
Wow,
I am.
You got a busy day.
I do.
You got a busy